So, to go through today's testimony, we're now reaching out to Joanna Smith, Ottawa Bureau Chief for the Canadian Press, and Chris Nardi, who's been covering the inquiry for the National Post. Good to see both of you.
Hi, Michael.
So, Joanna, as we heard...
Michael.
Hi there. So, as we heard, the CSIS director did not share the full story when he spoke to the Commission earlier this summer. How significant is this added assessment that ultimately the Prime Minister was advised to invoke the Emergencies Act?
I think it's pretty significant in that it supports the Liberal government's case that invoking the Act, in their view, was necessary. They can say, look, it wasn't us, it was CSIS. They know what they're talking about, right? They advised us to do this. But I think the key question is, did they know what they were talking about? And, Vigneault said the unpredictability of the situation convinced him the usual tools were not enough. But this was the case even though CSIS had already, been of the opinion that the protest did not meet the strict CSIS definition of a threat to national security, which is something we heard about last week in testimony from National Security Advisor Jody Thomas. The Emergencies Act really identifies a public order emergency as a threat to national security as defined by the CSIS Act. And that definition includes espionage or sabotage of Canada's interests, foreign influence, acts of serious violence, it goes on. So Vigneault said, there was no such threat. They were investigating some participants in relation to violent extremism and their potential to exploit people from the anti-vaccine, anti-COVID restrictions movement to violent extremism. But this definition didn't change. So the fact that he actually is saying that he advised the Prime Minister personally in that key meeting before the Emergencies Act invoked does give the Liberal government something to point to say this wasn't just something we decided on our own.
Yeah, give the government something to point to. And we're going to build on that. And I'm also going to build up on the definition. But before we get there, Chris, let's get you in on the conversation. What do you make of the director's reasoning? Because up until now, critics of the invocation have been pointing to that earlier CSIS assessment that the protest did not present a threat to security.
Well, it's certainly new information, and it's certainly information that the government must have just sighed a breath of relief that finally, they knew, of course, that he had recommended it, but it wasn't public knowledge, right? And it's kind of changed the discourse over how serious the support that the Liberal government had, the legal support had when they invoked the Act. Now they can turn and say, well, CSIS, the National Security Agency, one of the main ones in Canada, told us that we have this kind of broader threat to national security, even though, again, as Joanna said, it wasn't one as defined by the CSIS Act itself. So big sigh of relief for them, but there's also kind of an aspect, like a circular aspect here, where Vigneault talked about basing his assessment that yes, you should invoke it on a legal interpretation that he received from the Department of Justice. We've heard a little bit about this famous legal interpretation, but we have not seen it. And that was provided by the DOJ saying, well, it's okay to interpret what a threat to Canada's national security is broader than the actual definition that we have in the law. And, I think we'll talk about this a lot more, but it's kind of becoming a circular argument where he says, well, in this broader definition that the government gave me, then yes, you can invoke it for sure, but I haven't found the threat in the very specific definition that is in the law.
Yeah, okay, and let's get into it deeper now, because that really plays such an important part of what we're hearing, not only from Vigneault, but also what we heard earlier last week from the National Security Advisor, because part of his reasoning, as you both have said, is the definition of what constitutes a threat, because both he and the National Security Advisor believe that the definition as it stands is too narrow. So, Joanna, walk us through the argument that they're making here, because it almost seems like it's not the letter of the law that they're looking at, but more what they interpret the spirit of the law should be.
Yes, and this is something the Canadian Civil Liberties Association, for example, is calling a novel interpretation. And I remember I said this last week, but Ian Brodie, former Chief of Staff to former Prime Minister Stephen Harper, also tweeted, what a novel doctrine, sort of interpreting legislation on base what you'd like to see in it, not what's actually in it now. So that sort of remains a key issue. But I think, as Chris mentioned, a lot of it really rests on Vigneault talking about this was his belief that it could be interpreted in a broader way, in a different way, came from this advice he received from the Department of Justice. Now, That advice will not be shared with the public because the government has not waived solicitor-client privilege when it comes to the invocation of the Act. So we're really sort of stuck right now on this key question and not being able to have all the input I think the public needs to really interpret whether that was a sound choice. But that's sort of, as you mentioned, a circular argument right now where it's a little hard to tell who came up with which interpretation first. If Vigneault is saying that he gave the advice to the Prime Minister based on something he got from the Prime Minister's own government, then we're still not really figuring out where this all started.
Mm-hmm. And Chris, I'll get you to build on that because the ultimate question here, does that kind of argument fly? Because on the one hand, you have this live and fluid situation, but on the other hand, advice is being given based on what they think a definition should be rather than what it actually is.
See, Michael, this is the perfect case for an actual court to hear, right? A court that has time to look at this, to hear the legal arguments on both sides, and ultimately, conclude how the law should be interpreted. Unfortunately, we're not in front of an actual court, right? We're in front of an inquiry, a commission. And Commissioner Paul Rouleau, who I'm sure has the capacity to actually interpret these legal arguments, does not have either the mandate nor the time to do that. So we may get in his review that we expect to come out in around February, we may get kind of a broad strokes review of his saying, well, I kind of ascribe to this or I don't. We don't even know, in fact, if he's seen that document. He probably hasn't, because as Joanna mentioned, it's covered by solicitor-client privilege. So if he can't even make a determination of how good that interpretation is by the Department of Justice of how they view the law should be invoked, we're completely in the dark here. And so I really do not envy his mandate, which is to say, okay, well, the Department of Justice and the government gave all, and crucial members of government, including the head of CSIS, gave all these recommendations about the Emergencies Act based on advice that no one's going to see. And I can't even tell you if it has any legal strong, basis, because legal interpretations are just that. They're interpretations. They can be very good. They can be terrible. There have been some terrible ones. I can't speak to any of them. So unfortunately, it is a crucial piece of the puzzle that we're not going to see likely. And if we don't, well, it leaves the commissioner to make kind of his recommendations and his assessment of the use of the EA on incomplete information.
Mm-hmm. Listen, let's quickly switch over right now to the Emergency Preparedness Minister, Bill Blair, because as we talk about Vigneault, of course, we're going to have to see how that fits into the final report. But Bill Blair is the first cabinet minister to also appear before the commission. He did so today. Let's take a bit of a listen to the minister.
And we define critical infrastructure as 10 different sectors of critical infrastructure. And in particular, as it relates to this event, it includes such things as manufacturing, our transportation routes, the essential supply lines, the movement of essential workers. And what I was witnessing at the Ambassador Bridge, at Coots, at Emerson, and then in a number of different venues that where we would see similar activity being threatened to be done at Point Edwards, at the Peace Bridge, at the Pacific Highway in British Columbia, that escalation, and I viewed as a significant escalation because it did result in significant disruption of critical supply lines, the cutting off of essential goods and services, the impact that it was having, not just economically, but on people, on families, and people were being laid off their jobs, and factories were being idled.
So the minister essentially saying that he became very concerned about the economic impact. That's what elevated it for him into a national emergency. Joanna, Chris, I'm going to each get you take a turn on this. What did you make of the minister's testimony today? Where does it fit into the picture that Rouleau's trying to paint here?
I think it paints into this idea of whether the government thought it was necessary and whether other tools were exhausted. I did find it interesting that Blair concentrated so heavily on his beliefs about the damage that the border blockades were doing. I mentioned Alberta because we have heard testimony evidence from a Alberta cabinet minister who was frustrated in his communications with Blair, not getting the kind of help he was seeking. So to see Blair focused on that and sort of downplay the part that was taking place in Ottawa was pretty interesting in terms of I wasn't really expecting to see him display his thinking in quite that way.
Mm-hmm. Chris, what did you make of the minister's testimony? Again, the first government minister to appear before the commission. And it's interesting because what we heard seems to echo what we've heard before, that there was distrust that the police response as it was actually adequate enough to meet the challenge.
Absolutely, and we're seeing a lot of text messages and emails that he sent over the course of the convoy where he's seemingly particularly critical of the Ottawa Police Service and its chief, Peter Slowly. He talks about Peter Slowly foundering. At one point, someone reports to him by text, the chief seems exhausted, and he responds, well, he should get some sleep then, right? This kind of very profound dissatisfaction that, to be fair, he's actually quite backtracked here when asked about it in testimony. He's like, oh, no, I think that he had a very difficult mandate, and this was a very difficult job and an unprecedented situation. So he seems very reluctant to want to reiterate on the stand the frustrations that he was definitely putting to pen and to paper during the convoy. Ultimately, will that legitimize the use of the Emergencies Act? I couldn't tell you. Probably not. A lot of his frustration is very much geared towards the Ottawa Police Service and Peter Slowly. But the documents are such an important part of this whole inquiry, and the documents definitely show he was a frustrated minister.
Well, as we say, that is day one of what is the last week of testimony. Many more ministers, the Prime Minister also scheduled. So you and I, all three of us, will be speaking once again before this is through, without a doubt. But for now, Joanna Smith, Chris Nardi, always appreciate the time. Thank you for this.
Have a good night, Michael. Thank you.
Thank you.
Thank you. You too.